Hi, once again, I'm Ray Dickey from South Carolina, Hudson Valley, and Association Help Now. We have a great panel today. A lot of people from different states, a lot of attendees from different states. So always enjoy it. Always happy to see everybody here. We are going to do the four corners rule, which we'll dive into a little bit deeper. I think it's going to be a great program. It's about, how would you describe it, Cory, without going into the whole topic? If you had to describe it in one sentence, how would you? I know I'm putting you on the spot. How would you do it?
I'm assuming you're talking about the four corners, the authority that's given from a declaration, a condo declaration or an HOA declaration, and the authority that comes within the four corners of that document.
Cory had no warning. I had no idea if Cory even knew what it was, but he obviously did. It's about, once you understand it, you'll never look at contracts and policies and governing documents the same way. So that is our goal for today. If you have questions and comments, please send them. I'd love to hear back from the audience. Many times the audience dictates what direction the program goes into. I'm going to launch a poll. Let me find my poll thing here. If you are here, CEU. So I've gone ahead and actually already closed that poll. So let me take care of that. With that being said, let me have our panel introduce themselves with who I see first, and that is Christian.
Good morning, everyone. My name is Christian Saville. I'm with the law firm of McCabe, Charter, and Beverly. We represent community associations in Columbia, South Carolina. We have an office in Columbia. We have an office in Mount Pleasant. We represent HOAs all throughout South Carolina and North Carolina, and it's always a pleasure to be here with CAI.
All right, great to see you, Deb. Thanks for being here.
Good morning, everyone. Deborah Gerelli. I'm the Vice President of Gerelli Insurance Agency here in Cold Spring, New York. We have a team dedicated to community associations, HOAs, condos, co-ops in the tri-state area. And I have my CIRMS designation from CAI Nationals, and I'm happy to be here.
We are getting a big storm. Christian was talking about down in South Carolina. We're getting one in New Jersey. It's nothing for Deb. No amount of snow concerns her. They can handle it all up in New York. So, Cory.
Good morning, everyone. My name is Cory Kravit. I'm the managing principal of Kravit, Schifrin, Nesbitt's Florida office. We're a national community association law firm with offices in Florida, Illinois, Indiana, and Wisconsin.
Cory, if it's 50 degrees in Florida, do you put a parka on?
We freak out. Right now, I think it's like 75, so we're doing all right.
Oh boy, that sounds wonderful. John.
John LaGumina from the LaGumina Law Firm in Purchase, New York. We're a Westchester-based law firm representing condominiums, co-ops, and HOAs from New York City throughout the Hudson Valley areas.
Michael.
I'm Michael Pereira. I'm a senior attorney with Herzl Law. We represent HOAs throughout Michigan and also in Illinois.
If I remember right, Michael, you could die in your winter storms. People freeze to death. Is that true?
Yeah, probably. On my way here, I saw 2 accidents actively happening, and I was driving with one finger sipping a coffee because it's just a Wednesday.
All right. Dave.
Hey, good morning, everybody. My name is Dave Byrne. I'm the chairperson of my law firm's community association practice and Sugrum and Aaron, and I represent HOAs, condominiums, cooperatives in New York, New Jersey, and Pennsylvania.
All right. And just to get things rolling, I'm not going to do this as a poll. I want everyone to use their question feature and send me what they think the answer is, or some comments. I'm fine with. So there's 3 slides here, and I have a question. A contractor agrees in writing to finish landscaping by June 1st. Dave, you're so loud. So loud.
How? I'm not doing anything.
Okay. Can everyone hear Dave? Okay, it's fine. Okay. A contractor agrees in writing to finish landscaping by June 1st. Later, the manager verbally says, don't worry, you can finish by mid-June. The president says June 1st is the legally binding deadline. Is the president right or is he wrong? is the president. So I'm already getting responses out a lot. Well, it's overwhelmingly coming in right. And people are saying the contractor, it's a slam dunk. It's flying in and everyone is saying, right. I have not seen one person so far say that the president is wrong. And I think this is what the four corners rule is. And before you answer, Kristen, what I have as the four corner rules is it's a legal doctrine that says when a written document is clear and unambiguous, it must be interpreted only by what appears within the four corners of that document. With that being said, is the president right or wrong on this?
I would say that the president is likely right, with the caveat that, at least in South Carolina, a contract can be subsequently orally modified as long as it is a contract that could be performed within 1 year and subject to some other conditions. But most likely right, in keeping with the four corners rule, it is likely that June 1st would be held as that deadline because that's what's in the document.
So Cory, I was concerned about this topic when I came upon it, or maybe somebody sent it to me. I always thought a verbal instruction in many cases could be acceptable, and it didn't always have to be a written rule. But everyone is saying that the president is right in this case. Your commentary?
Well, you also have to look at the contract to see if the contract allows for modifications, only written modifications. And if that's the case, then certainly then the president would be right. But if that language is not there, then there is an argument that the president is wrong and that it could have been modified.
So you're saying there would need to be something in the contract that changes could be communicated in a certain manner outside of the written word?
Pretty much. Some contracts will say that a contract cannot be modified unless a written amendment is done or a written addendum, and it can't be modified verbally. And so if that language is not there, then it at least opens an argument for the contractor.
So John, you can just give us the answer on this one. If it is not written, it doesn't exist. Can we do this one as a true and false?
If it's not written, it doesn't exist.
Yeah.
No, you could have oral contracts. It's not 100% correct.
Does it have to be, the audience is coming in and saying false, by the way. Does it have to be, like Cory had mentioned, does it have to be specified though in the written contract?
Yeah, so I think the answer is, Cory's correct. If most contracts will have a clause, any change order needs to be in writing. So if you had that, the oral attempt to change the contract wouldn't work. The other issue is deadlines, or unless you write in that their time is of the essence, the court's going to give you a little bit of leeway on the deadline, and they're not going to hold you to the exact day and time.
So Michael, I also have here, the written text needs to be clear and unambiguous. What is that about? How does that play a role in all this?
Yeah, so the idea behind that is, look, courts are going to enforce contracts as they're written. They're not going to superimpose their understanding of what the contract says because they're not a contracting party. They're someone looking at it after the fact. And so the general guidance for courts is if the contract says something that's pretty clear, the court's not going to substitute its understanding for it.
I think that's critically important to know. I did not know that. I thought that if you communicated, like the manager had communicated that the deadline could be pushed back, I didn't realize that I didn't know that the judge was always going to revert back to the written word, which is exactly why I thought this topic was interesting. A lot of people, Dave, are a little bit confused about oral contracts. They're asking, well, oral contracts do exist, but I just want to go over the point, I think, one more time. According to what I heard Cory say, and John agreed, it needs to be written in the contract that the oral contract exists. Can you help us out?
I think I agree with what all the guys have said. If you have a contract with another party, and it provides that the only modifications can be done in writing, meaning only written modifications are enforceable, then that's the deal. Oral modifications are not enforceable. The risk you have, I guess, or one of the risks you have with with the verbal communications about these things is what we call reliance estoppel. Like if the parties talk verbally about doing something different than what's in the contract, and then the contractor relies on that, like, hires more people or buys more equipment or materials, and then you try to say later, oh well, I didn't mean that, and by the way, it's had to be in writing anyway, so that was not enforceable. A court could say, look, in fairness, you told the guy you were going to do it. You told him it was cool to do it on a verbal basis. He went out and spent 30 grand on the job. You should reimburse him with 30 grand. I mean, that stuff sometimes happens.
You had said though that it needs to be in the contract, that everything has to be written. Up to
Well,
this
I don't
point,
do. Yeah, I mean,
hold
I
on,
don't do. Oh,
like
sorry.
1 second, I'm sorry. Up to this point, I thought it was the opposite. I thought you could only accept. So let me just restart. Up to this point, I've heard that if it's not specified in the contract that you can make a change that's not written, you can't get away with it. But then you had mentioned, well, it needs to be in the contract that, you're not going to take any oral. You know what I'm getting at, Dave? Can you run with it and make it make sense for me?
If a contract provides that only written modifications are enforceable, then only written modifications are enforceable. That's a general practice. There may be estoppel reliance related questions. The parties may begin to make changes verbally, and then one party may try to back out later, and a court may not allow it to happen. But that's a case by case basis. But as a general matter, if your contract says no modifications unless they're written, then that's enforceable. And that's an important thing to do normally. I mean, I don't know if what everybody else will say, but I think you have a clause in your contract that says only written modifications are enforceable. You do that to avoid confusion, to avoid all the drama about he said, she said, and that guy told me I could show up at 9 o'clock. He told me I called him on the phone last night, said I didn't have to do that. And you avoid all that stuff, because that's where litigation comes. And then when litigation comes, that's where litigation gets expensive, because everyone has to testify about what they heard and what they saw and what they said to each other.
So Deb, from the insurance perspective, you see a lot of lawsuits, a lot of issues, a lot of misunderstandings about people, between people. Have you seen an issue like this where something was said verbally and it wasn't written? What's your feedback?
Yeah, so similar to what Dave was saying, we've had some breach of contract type claims come in because the contractor feels that the association breached their contract because they bought all this extra equipment to do the job, and then at the last minute decided not to, or didn't want to enforce that verbal agreement that they had, and the contract basically said that there was no that it has to be in writing, and it wasn't. So we do see those, and they're covered under your directors and officers for defense, but not for indemnity.
So there's a lot of scenarios here, Kristen. There's no hallway conversations, theoretically. Tell me if I'm right here, should take place. If you have a contract, you want to keep it within writing. That's how we've always done it, is another common excuse I think that people come up with. No verbal promises. And we're going to get involved in this one in a second. I'm going to bounce back to it because there's a lot of questions about that. But where are we as far as this goes, Kristen? We reached the point where what I'm hearing is, boy, you better have this stuff in writing, because it doesn't sound like a verbal agreement theoretically is going to hold up unless it says in the contract that you can issue orders that or changes that way.
Yeah, and I think it's an easy issue to get confused. When we're talking about the four corners rule, kind of as Cory had said earlier when he summed it up, it's really a rule that courts use to interpret written contracts. So the four corners rule is basically saying, if you have a written contract, we are going to only look at what that is written down in that contract when we're trying to ascertain the meaning of the contract. That's assuming it's clear and unambiguous. It's not necessarily saying that verbal contracts, like non-written contracts, aren't enforceable. It's just saying that when you do have a written contract and we're trying to ascertain what that one means, we're only going to look to the four corners of that document. We're not going to let other evidence come in like, oh, we really meant this. So it's easy to get it confused to misunderstand that the four corners rule means that there can be no verbal contracts. But it's really just a rule that is applied by courts in interpreting contracts that are there before the court. But I do think that, it at the same time underscores why it's not necessarily prudent at all to be relying on verbal contracts if you're an HOA, because then it gets so much more complicated trying to prove what was actually agreed to, what was intended. The fact that courts only look at the four corners of a document when you have a written contract in most cases really underscores how important it is legally and how important courts have deemed it that you have clearly written provisions in your contracts.
Cory, it sounds a little unfair, a little bit. I know lawyers like this kind of stuff and they're comfortable with it, but
No,
so it wasn't written,
actually
right? But go ahead.
yeah, it's actually the opposite. It's more fair because it defines how things are going to be interpreted. The court will only look to the document. It's not going to look at outside emails or other documents unless there's going to be an amendment to that document, and it makes it so there's an even playing field, and that's why it's even more fair.
Ooh, shocking. A lot of people are asking me and we're going to get into that, viewers, I haven't forgotten about it, but a lot of people are asking, does an email count, does a text message count? We're definitely going to get there to figure out if those count as written instructions or not. I'm kind of surprised Cory just said that they're not going to look at an email. John, some of the commentary that my research came up with is somebody may say, well, everyone understood what we meant. Or they may say that wasn't the intent. What do you think about that? I think we've determined that's not really going to play a role, right?
Yeah, I mean, that Cory just explained it. The four corners rules is we don't have to get into any of this extraneous evidence, whether it be emails, conversations, to discern what the intent was. It's if it's plain and unambiguous on the face, then that's all the court's going to look at.
But Michael, the board discussed it. It's in the minutes, but it never made it over to a written instruction, or it never made it in a contract. Is that going to play a role in court if it's in the minutes?
Depends how much you want to pay your lawyer. I think it goes back to what's on the paper matters. And if you discussed it at a board meeting, intended to put it in, why isn't it in there? Maybe you should shop around for a new attorney. But I was working with a client somewhat recently, and they asked me to do something. I did it. Then they come back and they're like, why did you do this? And I said, you asked me to. And they're like, well, we intended to let you know about this, not actually do it. And it's like the words that you use on the document matter.
So Dave, intent doesn't override text. Is that accurate or not accurate?
That's supposed to be accurate. I mean, the civil society in which we live is predicated upon the fact that if you want to avoid litigation and avoid drama and expensive disputes, you make a contract with another party. Therefore, if there's a dispute over price or service, you don't need to prove what you guys even agreed to. You only have to prove in court whether you actually breached it. If you don't have something in writing that's clear, you have to then first prove what you agreed to, which could be like a week-long trial. Then you have to prove whether there was a breach of what you agreed to, which would be another week of trial. So the society is based on the fact that, especially when you're dealing with an HOA or a condo and you're a corporation, you're going to hire someone to do something, contractor-wise, not necessarily an employee, but a vendor. You sign a contract so that there's no dispute as to what you agreed to, and no one has to spend any time or money on arguing what you agreed to. You only have to fight over whether or not someone breached it.
So discussion doesn't override documentation. Kristen, is that accurate?
Yeah, I would say in almost every case, yes. You can't rely on a verbal discussion, 2 years later when trial comes around and you're litigating over this, and you might not even be able to introduce evidence of that discussion. The court might not want to hear about it. So yeah, absolutely. Especially when you're a fiduciary of a corporation, you can't be relying on something that it isn't written down for something important like a contract.
Oh, that's interesting. I'll jump over to Cory. Are you not performing your fiduciary duty then, Cory, if you do not get something in writing technically?
Well, you should be relying on your experts and your attorneys to make sure that happens. So there's certainly possibly a case. It's probably be a long shot of breaching your fiduciary duty, but it's certainly a possibility.
All right, so there are some great questions here, and this is a great one, John, before we get into what emails and texts and other kinds of written communication, whether they matter or not. We sometimes have situations where we call a vendor for emergency work. These are the sort of one-off things, like removal of a storm, fallen tree. We don't have a formal contract. We just call and pay once the work is done. John, are we expecting people to kind of replace this interaction, or is this acceptable?
No, I believe Christian mentioned it before. If the contract is able to be performed in less than a year in New York as well as South Carolina, it doesn't have to be in writing. So you can do it in that. Usually you get a proposal, right? But if it's an emergency, you just get a bill. That's understandable. And that still works because it's an oral agreement and you have evidence of the oral agreement. You have, maybe you have some form of communication. So that is enforceable.
Give me that time frame again, John.
Less than a year.
So you can have an oral. So this is not going to be a factor in exactly what takes place within a year.
Yeah. So it's called a statute of frauds. So if it involves real estate, or if it takes more than a year, it needs to be in writing.
But what we're talking about here will still apply if there's some kind of dispute, or it will not.
No, like, so if there's an emergency, right, you got to winterize the unit. It's going to be 10 degrees tomorrow. You don't have time for a written contract. So you could do it, and it's enforceable even if you did it by phone call. All right, and you have no evidence of it, right? There's nothing in writing. You just have oral testimony. So yeah, like in what Dave mentioned, you might have a trial to prove what the terms were, but it is enforceable and it doesn't have to be in writing for an emergency.
Michael, is the court going to look at what kind of services you're hiring someone for in that case? Like if it's an emergency, it seems to make sense to me. If it's not an emergency, why can't it be reasonable to expect there to be a written contract?
I think that might cross a judge's mind, but again, it's just what John was saying, Christian was saying, like it doesn't, a contract for something that can be performed in under a year doesn't have to be in writing to be enforceable. And so that general rule is probably going to apply. The other side might make an argument of, well, this should have been in writing, blah, blah, blah. And it's an argument to make. I don't necessarily think it carries the day, but with these emergency calls, like, hey, a tree fell down, we need it removed, can you get out tomorrow? Yeah, sure, we'll do it for $1,000. Maybe a best practice, kind of what Christian was saying. I don't know if it rises to fiduciary duty level. Send a quick email back to the contractor. Just say, hey, thanks for taking my call. So happy that you can come out tomorrow morning at 9 a.m., remove our tree for $1,000. It's a recitation of what was agreed to on the phone.
So Dave, if you try to take advantage of this time frame, is it advantageous for the association not to have something in writing, or is it advantageous for the contractor? Why bother then, right? If anything theoretically goes. You're muted. It's okay.
It's never advantageous in my mind to not have not have a contract. I mean, I don't know why two parties would ever, unless there's some shadiness going on. But if you're looking to just operate in a normal commercial world, you have a contract with someone. It's really a best practice kind of thing. You can do verbal contracts all you want. I mean, you could agree to pay someone $50,000 to cut your trees down in your HOA if you want. We don't need that in writing. It'll be enforceable. But if the guy doesn't cut all the trees down, or he drops a tree on someone's foot and there's litigation, or he says you told him you'd pay him 65 grand and not 50 grand, you're gonna have litigation over it. And you're gonna spend time just simply establishing what it is you agreed to do and what it is you agreed to pay, and that's costly. And in a verbal contract, you almost never get your attorney fees awarded, even if you're right. So I don't know why, as an HOA or a condo, you would enter into any transaction unless it's an emergency without a written contract. I just don't know why you would.
So Cory, that seems like another big selling point here. Dave said that you won't get your attorney fees paid. I think what we're talking about here today and trying to get people to pay attention to is you really want to have something in writing.
Absolutely, and even if it's in writing, it needs to address the attorney's fees. At least in Florida, the only time you're going to get prevailing party attorney's fees if it's by contract or by statute. And sometimes with vendor transactions, there's no statute that governs, so the prevailing party attorney fee provision needs to be in the contract, which is why I advise all my clients, regardless of the amount of the contract, there's no contract too big or too small to send to us. Take a look at it to make sure you're covered, because the last thing you want to do is get into a dispute and the cost to litigate it outweighs the amount in controversy.
That reminds me of something that Dave has said many times. Dave, you constantly communicate, which I think is great because I've learned from it, that sometimes it's the small contracts that get you. It's not always the big ticket items. Did I remember that right?
Yeah, I think boards and managers are reflexively, sort of instinctively calling lawyers when they hire a guy to do a $3 million facade job. But they're not reflexively or instinctively doing it when they're hiring someone to do a $5,000 concrete repair in front of a clubhouse. But yet, if that's not done correctly, people will fall and they'll get injured and there'll be litigation over that fall. Or the construction won't have been done in accordance with the rehabilitation code, and there'll be disability related claims or some other type of thing. So you need to get contracts in place for much of what you're doing. And remember, like Cory said, if you hire someone and you don't have a contract, you don't have an attorney fee, prevailing party, or fee shifting clause, and a guy makes a mistake and it costs you $13,000, most of your lawyers are going to say, "I'm sorry, but you're probably going to have to eat that." I mean, it costs you more in legal fees to get the $13,000. So if you're not doing this correctly, you are basically creating a deductible for yourself. You're creating an amount of money that a contractor can basically steal from you, or harm you, and he'll get away with it because you can't afford to litigate over $10,000, $15,000, $20,000. So it's basically like a deductible. Contractor knows, if I harm this guy like 17 grand worth, if he has a good lawyer, the manager's going to know. If the manager's a good lawyer, she's going to know that she can't sue me for it.
But Kristen, are we telling people verbal assurances don't mean anything? But I've known the contractor for 10 years. The way I look at this is people will lie, especially if they don't own the company, when their own job is on the line. I am assuming, as an attorney, if you agree with me, can you tell all the people out there that never have had anybody lie about something like this, how it happens? That's why you guys are in business, right? People lie.
Well, I have worked in retail before and during law school and in customer service, and I can tell you that people will lie about returning something that is worth $10, and I can assure you that people will lie about things that are much more expensive and involve a whole lot more money at play. And while a verbal assurance in certain circumstances can be enforceable, it's not easily enforceable. It's going to take a whole lot more legwork and elbow grease from your lawyer to have it all work out than if you just have something in writing, clear and unambiguous.
All right, let me throw a scenario before I move on to what counts as written communication or not. you have a contract, you've been using him for 10 years, he doesn't own the company, he tells you something that results in a dispute over $20,000. The guy that owns the company is a real jerk. So the employee is afraid of losing their job. People lie. That's a scenario where you would never think that your contractor would lie, but they do. I'm just trying to push upon the fact here that these things happen and that people can
Absolutely.
manage the board.
Yeah. And lying is one thing, but there's also miscommunication. People think they heard one thing. I thought you said it'd be $20,000, not, $30,000. Miscommunication causes controversies as well, and misunderstandings. And especially in Florida, where you have people from all over the world, even though everyone speaks English, some people's understanding of certain words may not be the same, especially in contractual or business situations.
Deb, insurance companies are good about writing down every little thing. So I guess you're used to this and you're probably a big advocate for it.
I'm a very big advocate for it. We are constantly talking to our clients about making sure you have written contracts, making sure your attorneys review those written contracts, because we, at the end of the day, want to protect the association, and we call it risk transfer. We want to transfer all that liability back onto the contractor that's doing the work so that the association is protected. And that is only done with a written contract.
All right. So Dave, here we go. We've already kind of drilled it in people's heads that you really have to have a written agreement for the most part, even though you guys have provided some other opportunities where maybe you don't. But how about emails? I send you an email, tell you to do something, you have it in writing. Is that the same as having it in the contract?
Well, I think we're mixing up a couple different concepts. If you're telling me you have a contract, then the contract will govern what significance this email has. If you don't have a contract and the email says a certain thing, it might create a contract. It depends on the situation. It also might create what is called estoppel, reliance. Even without written contracts, even without verbal contracts, people sometimes are entitled to get money from you because you promised them something, and it would be unfair for them to not get money from you back. So I could come up with a bunch of different hypotheticals or examples, but that's that's like a law school 101 kind of thing. Regardless of contracts, regardless of anything in writing, there is a dynamic where if in the commercial world, if you promise something to someone or they reasonably believe you promised them something, and then you try to change or back out of it later, whether you have something in writing or not, they might be able to get money from you if they can prove, of course, that any of that took place.
An email, Michael, seems pretty clear cut. I send you an email, I tell you to do something, whether it's in the contract or not. I don't see how you can end up on the losing end of that, but is it possible that you could?
Yeah, absolutely. Like Dave said, contracts 101, first year law school. The contract textbook starts with 3 things are needed for a contract: offer, acceptance, and consideration. And so if we have a contract and we're trying to modify it through email, I tell you to do something, Ray. If you don't want to do it, there's no acceptance. So there needs to be, a reply to the email. Yep, sounds good. Get right on it. If it's no, or there isn't a response, then we have a question. But, I guess an email is something physical. It is in writing. It's better than a verbal conversation, but you just got to be careful.
John, a lot of people here, not a lot, like 4 are communicating that they use text messages a lot to communicate with contractors, and they feel that is a written agreement. Is that true or false?
Well, Michael just as he mentioned, yeah, it could be binding, but the problem with text is you lose them, right? So where is it? Or if you saved it, yeah, it's a communication. I don't know that it. There are statutes governing electronic communications. I don't know if there's a difference between text and emails. I know what I advise clients to do is not to use text, because I think emails are sufficient. I think texts are not.
I have a lot of Go ahead. Sorry, John. A lot of commentary about contracts here, which I'm not going to get to. A lot of technical aspects. We'll do that as a like standalone topic here. I'm reading this as I see it here, Christian. Our condo rules require that all new rules and amendments be approved by the board in an open board meeting. The definition of an opening board meeting is defined. A board of majority refused in writing to vote for a new rule. My question, Kristen, in regard to this is if it's at an open board meeting and the board said it in that environment, there's no debate about it, right? It's not an email or anything. Is the court going to look at that maybe as an advantage for someone if they're making the case that, the contractor should have done A or B or instructions were not given?
If the contract is unambiguous on the face of the contract, meaning if you look at what was in the contract and it's clear what was meant, then the court is not supposed to look at those surrounding conversations, even if it was said in an open board meeting.
Three people are.
Sorry to interrupt, but how would a contractor even know what happened at your open board meeting? Well, you could say whatever you want at a board meeting. It's only relevant to the third party if the guy or lady ever even knows about it. So how would that it might not even be relevant at all, what is said at a board meeting.
Right. And you guys have communicated that even if you send an email to someone, if you don't get a response, that's not going to help you out at all, even close to help you out. Correct? So
yeah, usually.
A couple people here are concerned, and this keeps popping up, and I'll go to Cory on this. How can we anticipate exactly what we may need from a contractor at the contracting stage of the relationship? Sometimes unforeseen issues are uncovered during the scope of the work and they're not under the contract. This is a common theme, Cory, because a lot of people have long-term relationships with these contractors. And I think this kind of makes them uncomfortable that if they're not getting stuff in writing, that they have to go to somebody that they trust 100% and say, you know what, we need that in writing.
Yeah, certainly. And usually the contract will provide or should provide change orders. You get into it, you open up a wall and it's not what, there's stuff that you don't expect and the scope of work increases or decreases depending upon the facts on the ground. So, what we see as, community association general counsel is the association will choose a contractor. The contractor will send the association their agreement or proposal, their contract. Let us put eyes on it, and I'll tell you exactly what's missing. And oftentimes we'll either amend the contract to protect the association, or we'll prepare an addendum to the contract that hits the points as their prevailing party attorney's fees is the proper venue where the association is located, insurance requirements, bonds, whatever. That's usually how we handle those situations.
So I think we're at the point now where I know the answer to this one. Courts don't, I know I'm repeating myself, but I'm trying to get people to kind of, if you don't catch it the first time, you can catch it the third time. Courts don't care what someone meant. They care about what the document says. For today, Kristen, can we, that this one's 100% true?
Yeah, I think that's a very fair summary.
Okay, excellent. And let me see if there's any other questions in regard to this. A lot of people have questions, like I said, about the text messages and things like that. I want to give you guys, I want to go back to this too. If the language is clear, outside explanations don't matter. During my research, John, I kept hearing that the court's just not going to want to hear it. It's almost like I felt like the court gets annoyed over certain circumstances when people come in front of them. Did I get the right impression in that regard? Like some of these situations don't have to be there and they're actually irritated about it and it could work against you.
Yeah, that's another way of stating the four corners rules. Courts will enforce it. Dave mentioned it before. You have to have some economic certainty with contracts. If every single contract is going to lead to like 3-week trials, then it's just going to be chaotic and so that's the reasoning behind the four corners rule.
And a lot of judges, Michael, are probably going to feel like communities live and die by their written documents. We're always talking about written documents, so why wouldn't this transfer into contracts? True or false?
Yeah, absolutely. I mean, community associations, they're governed by what's in their written governing documents. And so why should a contract with an outside vendor, be any different?
And lastly, this would apply, Kristen, to governing documents, board resolutions, vendor contracts, insurance policies, RFPs, meeting minutes, blah, blah, law? I'm talking about contractors a lot today, but can we expand this into other areas?
You can. In South Carolina and many other places, restrictive covenants are construed as contracts. And of course, a restrictive covenant would be if your HOA is having to, heaven forbid, sue a homeowner to comply with the covenants, then those covenants that you're trying to enforce are going to be construed like contracts. And so unless those covenants are ambiguous, the court is going to look to the four corners of your covenants and to determine the meaning. And of course, that does open some other, if they are ambiguous, that opens some other rabbit holes for HOAs when they're trying to enforce their covenants that might be at play. But generally, yes, I think if you take this principle of the four corners rule and apply it to all of your HOA documents, you'd be well served.
All right, let me stay with you and I'll move along because this person's kind of pushing me in this, and I don't mind that you're doing that, by the way, in the audience, so I'm not complaining about it in any way. Let me read the question again. They say this does apply to the topic, and maybe it does. Our condo rules require that all new rules and amendments are approved by the board in an open board meeting, and the definition of an open board meeting is defined explicitly. A board majority refused in writing to vote, sometimes it gets off, in a new open session on one new rule. I'm sorry, the way the system works. Oh, refused in writing to vote in open session on one new rule. Does explicit evidence in writing that the board did not comply with the open meeting requirement invalidate the rule and render it unenforceable? They're saying that governing documents are a form of a contract, and this would be related to our topic. So I'll start with you, Kristen. Am I missing something on this one?
I'm not sure. I want to make sure I'm not misunderstanding the question. So the contention is that a board did not comply with the stated procedures in its documents when adopting the rule. So the question is, in light of that, is the rule unenforceable? Am I understanding that correctly?
Yeah, I'm going to circle back to this. Like I said, I really don't understand it. So sorry about that. I tried to make it work. So I apologize if it was me screwing that up. All right, let's do closing thoughts on this one topic. And I have some other stuff to throw at the panel. And I will start with Deb. I'll start with you.
Okay, so my closing thoughts are contracts are super important. They lay the groundwork for expectations and timelines, and you should always be making sure you review those with your attorneys and even your insurance professionals to make sure that you are properly covered as a community association.
All right, Cory.
There are exceptions to the four corners rule, and we touched on it in terms of ambiguity and interpreting ambiguous terms. And I don't know if everyone knows what an ambiguous term would be. So I just wanted to touch on the exception would be where you can read a contract provision multiple different ways, and it's not clear from within the four corners of what what they're talking about, or it can be interpreted many different ways. So there are exceptions, and we touched on it lightly, but I wanted to throw that bone out there.
I'm glad you did, because it says it here many times. The language needs to be clear. It has to be completely understandable and clear cut in the contract. Is that what you're saying, Cory?
Right. So if it's not clear, you can use outside emails, text messages, other communications to define what the language in the document actually means.
And if the document is unclear, courts may look outside it. That's exactly what you just said, correct?
Yes, sir.
I like when you guys really do know what you're talking about, though, because I have like all these slides that I don't use, and you guys are like so ahead of the game and everything. It's actually pretty impressive that you guys actually remember all this stuff. Another thing I had is if it's clear, even if it's inconvenient, they won't. So it was back to this. If a document is unclear, courts may look outside it. If it's clear, even if it's inconvenient, they won't. Cory, does that make sense?
And that's the four corners rule.
Yeah.
If it's clear that you don't need to take outside any kind of outside noise, because it's perfectly clear as it is.
Hey, John, I'm hoping I could kind of hit you up with your closing statements. I have 4 things to think about as far as a checklist goes for people. Write it like someone else will read it later, and you stop me if you disagree. Document decisions immediately. Amend in writing or don't amend at all. Amend in writing or don't amend at all. Assume silence will be filled by a judge. What do you think about those?
That sounds
No,
like
I mean,
AI.
yeah, that sounds like AI. So it's all about clarity, right? We've said that several times. You want to make it clear. You don't want any ambiguity. It could be construed against you. So you want clarity. You want to know you're getting the deal you think you're getting, and the more clarity, the better. Like even in contracts, you could write like, here's an example of what I mean. That makes it even clearer. So yeah, so the role of the contract is to be as clear as possible, so you don't have to go beyond the four corners.
So Michael, you guys were all laughing. Which one is wrong here then? Right? Like someone else will read it later. That's acceptable, right?
No,
Doc,
that's great. That's great because boards change.
okay, document decisions immediately. That one is correct, right?
Yep.
Amend in writing or don't amend at all. That's correct. So is this the one that you guys had a problem with? Assume silence will be filled in by a judge.
Yeah, I mean the general rule of thumb, and again, I think talking with a panel of lawyers is everything depends, and for every rule there's five exceptions. But for the most part, four corners. What's on the paper matters. If it's not in a contract, there it will likely be presumed that there's a reason why it's not in the contract. There's certain things that could be considered gap fillers, if I remember Contracts 101 correctly, but I would not live or die by that statement at all.
Okay. Dave, closing thoughts. I'll let you close this out on us.
Yeah, no, I'll say just one thing. Follow. I think Cory was sort of making this point. I think is that like many states have these statutes where there's no transaction unless it's in writing. We kind of talked about that, but also like New Jersey has a statute that if you're going to a contractor cannot do. Let me say it this way: New Jersey has a statute that it's per se rebuttable presumption consumer fraud for a contractor to do home improvement related work without a written contract. So, in some ways, owners might, we mentioned ironically before about an owner might actually, or an HOA might actually get benefited by the fact that there's no written contract in some odd sort of way. But every state has these weird little quirks where they read stuff into a contract, or they say that it's fraud to do something without a contract. Your lawyer, I think, should probably be able to help you with those things based on what state you're in. But those are really interesting quirks. Like I said, New Jersey has one that says a contractor is committing fraud if he or she does any work to the roof of your clubhouse but doesn't give you a contract for it. That might be fraud, even if the work's good.
So that will definitely be used against the contractor and be the advantage for the association.
Right, be leverage and that sort of thing.
I don't think I want to make I feel like I would want to get everything in writing, right, Dave? But like, I don't want to make, that's why I don't want to make a blanket statement that contractors all the managers here and board members have had these long-term relationships with contractors. And I think it's just very comfortable and very common for them just to get all these little projects done without any kind of agreement. And I guess that's fine until something happens.
Well, John made a good point. I think it was John before said, I mean, having a contractor email you a quote unquote proposal that you put your initials on as a manager and send it back, that's a contract. That satisfies what I just brought up about the statute in New Jersey vis-a-vis fraud. So, that's Sunday night, you need someone to do something Monday morning, contractor sends you something, you send it back with your initials on it. That is a written contract.
Deb, why don't you scare people because you're good at that? Give us some scenarios where like what seems like a simple.
Not physically though, Deb, just like, how you talk and stuff.
Right. Give us some examples of where not having a written contract where some simple verbal instructions to a contractor could turn out to into some kind of horrible situation. I mean, I could probably think of a couple, but go ahead.
So the reason why we do written contracts is so that's clear, right? That's what everybody's been talking about today. So when something goes wrong, it's clear on who is responsible. So we've had claims, where they hired a roofer to patch a roof and they didn't have the proper insurances in place. Somebody falls off the roof. Who's responsible? If you have a contract, that's usually clear and concise on, risk transfer and who's responsible. And there could be exclusions in insurance policies for such an incident. So we want to make sure that we're properly protecting all parties, even the contractor in that case. You want to make sure we're protecting everybody properly. And these little things like that happen. Somebody goes up on a ladder to clean gutters or, clean out or just make a patch or check on a roof, they can get seriously injured. And without a contract in place clearly explaining who's responsible for what, it becomes a very messy situation.
Somebody sent me a good one. I'm going to have to reduce it a bit here, so sorry about that. Let's say you have a small railing that you need replaced over a small bridge that goes over like a little creek or something like that. You don't have a contract and the railing fails and somebody falls into the water and dies, right? Well, then there's going to be a debate because you don't have a written contract exactly what you're expecting the contractor to do. They could say, oh, well, you know what? You didn't tell me that you needed a safety inspection. You didn't tell me this or that. That's a pretty darn good example, right, Deb? Where like a small ticket item, just replacing a railing or just going out there to do some work. Oh, I like when Kristen's agreeing with me. I think he is, at least, because he's not nodding his head. That's a prime example of a little project to just go mess around with a railing to a certain extent and do some replacements on it could turn into a big problem if you don't have a written contract. Is that true?
That is true, right? And did you vet that contractor? Did they have the proper skills to do it? And do they know the specifications? Like, I mean, if that railing's not properly installed and then fails, you definitely have a bigger problem.
There you go. Kristen, were you agreeing with me or were you just nodding your head because you were falling asleep? Which one was it?
I was absolutely agreeing with you and Deborah. And, I would also echo what Cory had mentioned earlier about how he advises clients, to provide, contracts for the attorney's review, even when it seems, relatively insignificant, because significant liability can come from what seems like small projects. And, it's so tempting when you're dealing with a small project just to say, oh, you know what, the parties, we know what we mean with this contract. Let's just draft something up real quick. And, based on everything we've talked about today, what you meant could mean very little in the face of what's actually written down in that contract. So that underscores the importance of running things by counsel when you're entering a contractual relationship.
All right, here's a great question. I'm reading it as I see it, audience. A condo officer tells tree remover to cut stump to 24 inches. Contractor cut the stump down to 24 inches instead of cutting the height of the stump to 24 inches off the ground. Owner's very upset.
Interesting.
Contractor wrong to listen to owner instead of manager. Not worth litigating, unable to replace tree. I think I did a pretty good job of reading that. I'll go to Dave since he seemed to like the question.
Yeah, I did like it. I was actually thinking about it, a good example that you could come up with, because although I don't know if this goes to the question as much, but if someone trips over that tree stump, it's not so much that you don't have a contract. Deb's point about not having insurance stuff, that's important. But if there's a dispute over what the guy was supposed to do, like was he supposed to cut 2 feet off it or 2 feet from the ground, then you have litigation. And let's say it's, I don't know, who's a famous athlete right now. Let's say it's the Mendoza guy from Indiana, the quarterback, and he's going to get a gazillion-dollar contract next year in the draft, and he trips over your tree stump. You have a serious lawsuit ahead of you there. But the contractor and the association are going to be arguing over was the tree supposed to actually be cut down to the ground, or was it just supposed to be cut down a little bit? And the absence of a clear specification on what to do is going to be a problem right there, leaving aside the insurance issues and stuff. I'm just talking about the contractor's going to be like, it wasn't my job to cut it that low. You only told me to cut off 2 feet, not 2 feet from the ground. You know what I mean?
Yeah, this is better than my railing example. I was like all proud of myself with my railing example, but I actually think that this is a better one. So I think they said that
the railing example is tough because some of that stuff's covered by like code, building codes. Like even if you don't agree with your contractor about what he's supposed to do, he's supposed to do it anyway because there's like a code involved. You know what I mean? The cutting of the tree thing is probably a better example because it's not necessarily something that the contractor is automatically supposed to do because it's not governed by like a building code.
Deb,
But
you
Dave,
know,
let me just say something I wanted to talk about. You really shouldn't be contractors should never be taking direction from a homeowner, right? They're
Yeah,
contractors
yeah.
with the association. So the fact that, Mrs. Jones comes
Right,
out
right.
and says, no, I want the tree done this way, that contractor really should never take that direction.
Right. Yeah, that's yeah, that example. I was taking it as like a title example between the association and the contractor as to how you could really end up in a big problem just on a standard disagreement over what the work was going to be. But you're right, the contractor taking direction from an owner is probably going to be screwed in the first instance, because that's a clear no-no.
so Dave, you actually came up with a way too that my railing example was not even a good one because of zoning things. Kristen, it's such a joy to deal with you. He was so nice to me before he went live. He was like complimenting me. Michael, I don't get any compliments. Kristen gets on. He compliments me. It's just a joy to have around. Dave and John and Cory, they're just.
In all fairness, he has known you longer.
They're questioning my legal knowledge constantly. Okay. All right. I had a bonus thing to do here, which I thought would be, and thanks so much for sending that in. Much appreciated. So I would like to try to get to one of these, and it's a bonus topic, and you have to pick a number, and it's at random which question you will get. So Deb, which attorney do you think we should put on the spot first, and what number would you like them to have to respond to? And they have to do it quickly.
Let's go with John, and he's going to do number 4.
Number 4. John, what is the toughest call you've had to make professionally?
The toughest call I've had to make professionally?
Yeah.
Like a phone call he had to make, or like a decision?
Come on. Everything's so unbelievable. You know what I mean, Dave. Now you're just toying with me.
Whether to keep a client that I don't want. How's that?
I don't know. I don't know what answer. That didn't see. I think John could have done better on that. I think he was kind of holding back, and I don't think he wanted to share with us, but that's okay. All right. Dave's agreeing
so it's
too.
a hard decision.
All right, Deb, give me another one.
All right, we're going to go with Dave because I always love his answers.
Okay, that'll fill in the last 2 minutes for sure. Number 2. Dave, one mistake you see repeated over and over.
Oh my God, that's such a great question. The first thing that popped into my head was boards adopting rules that they have no intention of enforcing. And then they end up with owners wondering why they're not being enforced. They end up in litigations over rules they never wanted to have in the first place. So I guess the mistake I see over and over again is boards not thinking out 5 or 6 steps down the road with respect to every rule they're adopting. Like basically, if this is violated, am I prepared to pay a lawyer to go to court to get enforcement? If I'm not, I ought to just probably drop the whole thing.
I know you do hate that because you do bring
I
it up.
Yeah.
You really hate that a lot. You don't want a rule unless you're like,
right, guys, it affects us lawyers where it's, your clients contact you about a rule that's been violated by an owner or a series of owners, and you start to walk them through the process of getting enforcement, and all of a sudden they're like, oh, I don't like that. And then you're like, well, then why do you have the rule? Because now you're stuck. I mean, like, what do you know what I mean? Like, that's why you guys probably all face that kind of thing too.
Yeah, you want people to, you would like boards sometimes, Dave. You're an advocate, and well, this sounds, I know you mean best, but like people, sometimes boards need to have money go out of their pocket to enforce a rule, even though financially it would make sense sometimes to let it go. Would you agree or disagree?
Yeah.
Okay. All right. We don't have time for any more. I want to thank everybody for being here. Any questions that I did not get to, I will get to and get back to everybody. And I know tomorrow we have a managers forum. I don't know what the topic is. Oh, about promoting yourself if you're a manager, but I'm sure there'll be other stuff going on. But I want to thank everybody for being here. I look forward to seeing everybody tomorrow. Thank you so much. Bye, everybody. Thank you.
Bye.
Hey, everyone.